There's a significant case now in front of the U.S. Supreme Court that challenges the National Firearms Act, NFA, and its restrictions on short-barreled rifles. What makes this development even more noteworthy is how the Department of Justice and, notably, the Trump administration have chosen to respond. It's a strategic move that deserves close attention. Before getting into the details, if you'd like to support the channel, please consider subscribing. It helps the channel grow and ensures you stay informed on critical Second Amendment updates. Also, leaving a comment below lets the platform know this content matters and helps it reach more people. Now, on to the case. The Supreme Court is being asked to review whether the NFA's restrictions on short-barreled rifles are constitutional under the Second Amendment, especially in light of recent rulings in Bruen, Rahimi, and other related decisions. The petition argues that the court should step in to clarify the confusion among lower courts regarding which items qualify as arms and are therefore protected under the Constitution. Although the court recently declined to hear cases involving rifle magazine bans, raising concerns about how likely this case is to be taken up, the NRA and other supporters are continuing to push for Supreme Court review. What makes this situation particularly interesting is how the Trump-era DOJ has responded. Rather than filing an immediate response to the petition, they submitted a formal notice waiving their right to respond, unless the Supreme Court specifically requests a reply. This decision is telling, and it could suggest a number of strategic calculations. We'll take a closer look at what that might mean for the case going forward. The Supreme Court petition, Mr. Rush has now officially filed a petition with the United States Supreme Court, asking the justices to overturn both the Seventh Circuit's decision and the original ruling by the lower court. In his petition, Rush argues that his motion to dismiss the indictment should have been granted based on the protections provided by the Second Amendment. He is asking the court to rule that the National Firearms Act, NFA, and its restrictions on short-barreled rifles, SBRs, are unconstitutional. The central question presented to the Supreme Court in this case is this: does the Second Amendment protect the right to possess unregistered short-barreled rifles that are in common use for lawful purposes? In the petition, the National Rifle Association, NRA, advocating on behalf of Mr. Rush, emphasizes the ongoing legal confusion since the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen. Since that ruling, courts across the country have struggled to apply the new constitutional framework, particularly when it comes to defining what qualifies as a bearable arm under the Second Amendment. This case, the petition argues, presents an ideal opportunity for the Supreme Court to address divisions among the lower courts and to clarify the scope of the Second Amendment. While the specific focus is on short-barreled rifles, the broader implications could affect other legal challenges, including those involving magazine bans and so-called assault weapon restrictions. Key arguments in the petition. The petition strongly asserts that the Second Amendment protects all bearable arms, including short-barreled rifles, if they are commonly used by law-abiding citizens for lawful purposes. The argument takes direct aim at the Seventh Circuit's conclusion that short-barreled rifles are not protected by the Second Amendment. According to the petition, the Seventh Circuit created its own test for determining protection under the Second Amendment, one that cannot reasonably be satisfied. The court's reasoning, the petition says, was contradictory. On one hand, it dismissed the growing popularity and widespread ownership of short-barreled rifles as irrelevant. On the other hand, it claimed Mr. Rush failed to prove that these firearms are commonly used for lawful purposes. The petition points out that this logic is inconsistent with the standards laid out in Bruen and Heller. In fact, the authors of those very opinions have criticized approaches like the one the Seventh Circuit adopted, which appear to conflict with the Second Amendment's core principles. To further support the argument, the petition provides data showing that there are at least 532,000 registered short-barreled rifles in the United States. That number, they suggest, may be even higher when accounting for unregistered or misclassified firearms. This widespread ownership, they argue, demonstrates that these rifles are in common use and should be protected under the Constitution. Another important point raised in the petition is the lack of historical support for the NFA's registration and tax requirements. The NRA argues that the government's historical comparisons, such as colonial militia laws or early taxation measures, are not meaningfully similar to the modern regulatory structure imposed by the NFA. As a result, they argue that these comparisons cannot justify the current restrictions. The petition also revisits the 1939 Supreme Court decision in United States versus Miller. Contrary to how the lower courts interpreted Miller, the petition argues that the case did not definitively rule that short-barreled shotguns or rifles are unprotected by the Second Amendment. It simply held that the government hadn't provided evidence showing that those specific weapons were useful for militia service. Moreover, Miller never directly addressed short-barreled rifles, meaning it shouldn't be used to justify blanket restrictions on them. So, what happens if the court finds that short-barreled rifles are in common use and protected by the Second Amendment? In that case, the NFA's restrictions, including registration and taxation, could be declared unconstitutional. That's why the petition urges the Supreme Court to take up the case, provide clear guidance on the definition of protected arms, and determine once and for all whether SBRs fall within the Second Amendment's protection. The Trump administration's response. As previously mentioned, the United States government, through Solicitor General John Sauer, has officially notified the Supreme Court that it is waiving its right to respond to the petition filed in this case. The notice submitted to the court states that the government hereby waives its right to file a response to the petition in this case unless requested to do so by the court. Now, it's important to understand what this typically means. When a party waives its right to respond to a petition at the Supreme Court level, it generally indicates that the party does not believe the case requires a formal response, either because they view the petition as lacking merit or because they don't expect the court to take it up. In some situations, this can also be a procedural move to accelerate the court's review process, especially when a recess is approaching. In this instance, timing may be a key factor. The Supreme Court is set to begin its summer recess soon, with its final conference and consideration date reportedly falling on June 26th. By waiving the response, the administration may be trying to speed up the court's consideration, potentially positioning the case for a decision on whether to hear it in the next term. Possible strategic implications. On the other hand, it's also possible the administration simply believes the challenge lacks merit and sees no need to respond unless the court compels them to. That said, in recent legal battles, including cases involving suppressors, the administration has taken the position that while items like suppressors may be protected under the Second Amendment, the National Firearms Act, NFA, is still a constitutionally valid regulatory framework. If the court does request a response, it's likely the administration will maintain a similar position here. They may concede that short-barreled rifles, SBRs, are indeed arms within the meaning of the Second Amendment, but argue that the NFA's registration and taxation requirements are consistent with constitutional principles. It's possible that the administration is choosing not to take a definitive stance right now unless prompted to do so by the court. It's also worth noting that the Trump administration has recently been very active in defending Second Amendment rights. In suppressor-related cases, they argued that suppressors are protected arms. They also intervened in the Illinois PICA challenges, taking the position that AR-15s and standard capacity magazines are protected under the Second Amendment, and that statewide categorical bans on such items are unconstitutional. So in this case, the decision not to respond immediately could be part of a larger legal strategy, either to move the case forward quickly or to avoid putting their legal arguments on record unless necessary. Looking ahead. What happens next will depend on whether the Supreme Court decides to ask the administration to respond. If they do, it's possible we'll see an argument similar to the one the government made in the Fifth Circuit's Peterson case involving suppressors, acknowledging that the NFA regulates protected arms, but asserting that the regulation itself is constitutionally valid. That would be a significant development, especially since the government's position can influence whether the Supreme Court decides to take the case. Historically, when the United States government urges the court to review a case, the court often agrees. For now, we're in a waiting period. We'll see if the Supreme Court moves on this case before the summer recess. And if so, that could indicate the justices see potential merit in reviewing the challenge to the NFA's regulation of short-barreled rifles. As this case progresses, I'll continue to keep you updated. Thanks for watching, and if you found this helpful, be sure to like, comment, and subscribe for future updates.